start.
Off to a great start. Okay, I'll make sure this is down.
So we're
Okay.
3 minutes early, so it should be starting any minute now. If it hasn't started by 1:35, but they
We'll just
do have,
wait.
they do have other cases before usually, so.
Thank you.
All right, well, good afternoon. I think we're ready to begin our afternoon court session, and we can do that by calling the State of Wisconsin versus Marissa Fuchs. It's case number 25 CM 2850. May we have appearances, please?
State by ADA David Olson. Marissa Fuchs appears by video conferencing software and by attorney Paul Frederickson in the courtroom. Good afternoon, Commissioner. Ms. Fuchs, you're currently on mute. Do you have a copy of a criminal complaint charging 4 misdemeanor counts? You just give a thumbs up if you do. Okay. We have received a copy. We'd waive any reading at this time. She would stand mute. I don't have information about the address or her eligibility for public defender services, Commissioner.
All right, thank you. And just for the sake of completing the court record, she is not incarcerated in the Dane County Jail. I believe she's appearing remotely from the hospital. We should talk about your right to a lawyer, ma'am. The law says that you would have the right to a lawyer on charges like this. Could be a public defender if you met their income guidelines, and we'll make sure to get you some paperwork that talks about how to apply there. You also could hire a lawyer on your own. You could choose to represent yourself. Those are all options. You have a good lawyer here helping you today, and so you're in good hands in that respect. We're going to take up the issue of bail and conditions of bail in just a second. Before I hear from the lawyers about that, my understanding is that Aaron Fuchs is present via Zoom, and that that person may want to be heard regarding bail or conditions of bail. If that's the case, sir, feel free to unmute and share those thoughts.
Hi, yes, I'm Aaron Fuchs. I'm Marissa's husband. Speaking on her behalf, I would like to advocate for a reduction or kind of elimination of any bail terms. It is my full-chested opinion that this was an isolated incident brought about by a severe stress-induced mental health episode. In the 6 years that I have known Marissa, she has never been a violent person. She has never been an angry person. And going through it, I am someone who has a background in armed security, de-escalation, and things like that. And she was not in her right mind. I believe that was escalated by the incorrect diagnosis and incorrect medication she was taking at the time for what was erroneously a generalized anxiety disorder. We know now from the medical assistance she's been given that was an incorrect diagnosis, and they have her on the correct medicine. We have been talking for the last several days. While she is in the hospital, we've been making phone calls, and she is back to the Marissa I know. So I like I said, I would like to request that there, be as few or as limited requirements as possible.
I appreciate that information. Thank you for sharing it. State have a position on bail?
Yes, Your Honor. I'd be asking for a signature bond that she have no acts or threats of violence towards Aaron F. That she not possess any controlled substances without a valid prescription. She not use or possess any alcohol, no use or possession of dangerous weapons, and she takes all of her prescriptions as prescribed.
Okay, thank you. And the defense position?
Ms. Fuchs, did you understand what the state was requesting for conditions of bail?
Yes,
Do you have any objection with those conditions at this time?
no,
Okay, no objection.
Okay. A signature bond is not necessarily an automatic in a case where there's an allegation of battery and intimidation, and I think there's also a physical resisting allegation. I do put a lot of weight on what's been described as this being not normal, that it's being an aberrational set of events that seems to be borne out by any stated lack of criminal history. For those reasons, I'm willing to go along with the joint request for a signature bond. I'll adopt the various non-monetary conditions that were proposed, except I'm not going to order the specific ban on controlled substances or drug paraphernalia, simply because that duplicates the law anyway. It would be punishable as a criminal law matter, and also would be a violation of bail because of the generic no crime condition of bail. So I tend not to order that. The other conditions, including the one to take any prescribed mental health medication, those conditions are being adopted. We'll get a not guilty plea entered on Ms. Fuchs' behalf. I hope things improve for you and also for you, sir. I hope things work out. Take care.
thank you so much.
You're welcome.
Thank you.
Bye-bye.
Next up is Olivia Thompson.
She was. Cool.
Yeah, I didn't think that happened, but I wasn't sure when I looked back at the CCAP record.
Sure. Well, why don't we call the cases of
Yeah.
the state versus Olivia Thompson? There are cases 25 CM 1652 and 25 CM 2853. Appearances, please.
State by 88, David Olson.
Olivia Thompson appears in person in custody by attorney Paul Frederickson. Good afternoon, Commissioner.
Good afternoon. So we do have two things on the calendar today. One is a bench warrant return hearing in case 25 CM 1652. The other is a new initial appearance in case 25 CM 2853. The bench warrant was issued on November 26th after and I'll put this in quotes, missed hearing in front of Judge Kandar. It's pretty clear from the booking record and from the information described in the new complaint that she was in custody here at the jail when that occurred. That she was in custody, and likely that wasn't like a volitional miss. We do have to address bail technically because it's a return on a warrant that was issued, but we have that background information.
Sure.
We also will address bail as part of the initial appearance in the newer case number 2853. By local court rule, we have to get that case assigned to the same judge, to Judge Kandar. Does the state have a position on how to proceed on these cases?
Your Honor, I'd have no objection to recalling a warrant since it's not, and then reinstating that prior bond, and then perhaps just having the initial appearance on the newest matter.
And from the defense perspective?
That's fine, Commissioner. We have a copy of the criminal complaint in the new case. We'd waive any further reading. She'd stand mute. She's eligible for a public defender, and the best mailing address when everybody's ready is 318 Kent Lane, number 104, Madison, Wisconsin, 53713.
Sure, and I think it gets technical, but I think because the warrant got issued and has been served, we have to treat this as a bail hearing rather than just withdrawing it. But I will reinstate the signature bond previously in effect with the same conditions. And if the clerk hasn't done so already, I'll ask that he include a note in the CCAP record in connection with that warrant entry that explains that that was issued because it wasn't recognized that she was in custody at the time.
Mm-hmm.
So that doesn't, hopefully that won't get used against her in any future analysis. What's the state's position regarding bail in case 2853?
In 2853, no objection to a signature bond, no contact with Georgina J and Antonio R. I'll give you spellings. That is GEORGIANA and the last initial J. Antonio ANTONIO, last initial R, and then also a condition of no possession or consumption of alcohol.
No objection, Commissioner.
The complaint doesn't actually charge a resisting or an attempted battery type count, though there's a description with an underlined heading entitled resisting on page 4 that describes an attempt to kick at a police officer and some physical resistance. I guess I'm interested in more information about why this is an appropriate signature bond case.
Your Honor, I think given the fact that she has these two cases open, she was in fact in custody for them. The reviewing prosecutor saw fit that a signature bond was an appropriate recommendation here if it's only to ensure her future appearance in court.
And Mr. Frederickson?
Well, obviously, I don't object to a signature bond, and they didn't choose to charge the resistive behavior, which I think is certainly a mitigating factor in and of itself, Judge. It also does look like she was being taken in to get medical clearance, which is also sort of a flag to everybody involved that there might have been other things going on than just physically resisting or obstinance, Judge.
I don't see that we have a PSA for this case, so I don't have a lot of information about history. It also appears that there was not one filed when she first came through the system on the earlier case. Anything either counsel wants to add before I make a decision here?
No.
All right. Well, I'm supposed to give some weight to the recommendations that are made by the attorneys in cases, and I'm going to do that. I will, based on the joint recommendation of the parties, order a signature bond with the requested conditions. Ms. Thompson, I guess I don't want to sugarcoat this too much for you. I think if the state had asked for cash bail, it's a very high likelihood that there would have been a cash bail order. The state, for whatever reason, has agreed to allow your release on a signature bond again, despite this being an Act 3 eligible complaint with a weapon allegation, and despite the resistive sort of behavior. I'm not holding the missed court date from the other day against you. I totally get that wasn't on you. But it's this is a real close call as to whether I should go along with this or not. I'm going to do it with some reluctance, but I hope it works out. We're all better off if you are not sitting here in jail and you're out and you're not picking up new charges and not responding this way to police officers when they're investigating something or any of that. And I hope it works out for you. We'll get you set up with some paperwork here in the next room. Ms. Thompson, take care. You're welcome.
Next up is Sandy Graham.
All right, we'll call the case of the state versus Sandy Graham. It's case 25 CM 2846. Appearances, please.
State by ADA David Olson.
Sandy Graham appears in person in custody by attorney Paul Frederickson. Commissioner, we have a copy of the criminal complaint. I waive its formal reading at this time. The address on that complaint is accurate. I am not aware of whether or not he's eligible for public defender representation at this time.
All right, thank you. And the deputy is going to give him a sheet that describes how to contact the public defender. You can do that by telephone. You're also free to hire a lawyer on your own or to represent yourself. Those are all options. You're in good hands here today. It looks like Mr. Graham got brought here from South Bend, Indiana in connection with an ES or parole hold. He remains in custody on that hold. But I'm bringing this up in part so that we're all aware of that form of custody, but also because that case was handled by Judge Burrs, which means by local court rule, we have to get this case assigned to Judge Burrs also. Does the state have a position regarding bail in the new misdemeanor case?
Yes, Your Honor. In this misdemeanor case, I'd be requesting a $5,000 cash bond. No contact with Jadon C, JADON, last initial C as in cat, and a ban from the 600 block of Sand Pearl Lane in Madison, in addition to no alcohol. The defendant is required to be on the sex offender registry for his entire life following a conviction for second-degree sexual assault of a child in 2021, as well as a separate conviction for third-degree sex assault. He was just released from prison in January of 2025, required to comply with GPS monitoring. And after the assault, he was tracked to Green Bay, and then the signal was lost due to device not being charged. As you pointed out, he's currently on a hold. He's on absconder status. He had to be brought here from out of state. We have some missed appearances here from June 13th, 2017, August 10th, 2017, March 13th, 2018, September 26th, 2018, and October 23rd, 2018. So for all of those reasons, I think cash bond request here is warranted and called for.
And the defense position?
Commissioner, for those reasons the state indicates, I'm gonna ask for a cash bill to be set at $500. I think some amount of cash bill is appropriate. I think also it is important to keep in perspective that this is charged as a criminal misdemeanor matter. Apparently he is on an extended supervision hold, which means there would have to be some hurdles for him to be released. He would have to be given some sort of alternative to revocation, or he would be subject to supervision if released. I don't have any information about his ability to pay any further cash bail, but I think $500, given this is a misdemeanor charge, is appropriate, Judge.
Any response from the state?
Your Honor, I understand these are just misdemeanor charges. However, I think given all of those factors as outlined, there's a serious, let's say, concern about Mr. Graham appearing to court if he is released from his DOC hold.
And I think that's a fair analysis or a fair point, that there's reason to set cash bail here. There's the nature of the offense in combination with the prior history that increases the likelihood of incarceration and maybe significant incarceration, even on a misdemeanor charge. There's the flight related issues. There's also the alleged noncompliance with the registry, though that itself could be the basis for a separate charge that has apparently not been brought. So I'm not going to set bail on an uncharged crime of that sort. My number is a fair amount closer to the defense number, I think. I'm not going to set it quite that low, but I will set it at $1,000. I'll order the two requested non-monetary conditions. They're appropriate given the charges, and we'll get a not guilty plea entered for Mr. Graham.
I'm sorry, Commissioner, I think there were three, the no contact of Sand Pearl and no alcohol.
Oh, I missed the alcohol one. I think that is appropriate given what's described in the complaint. All about it. Yeah. All right. Good luck to you, Mr. Graham. Take care.
Next up is Jeremy Elisius. Delicious. I would never ask for this.
All right, we'll call the case of the state versus Jeremy Elisius, case 25 CM 2849. Appearances, please.
State by ADA David Olson.
Jeremy Elisius appears in person in custody by attorney Paul Frederickson. Commissioner, we have a copy of the complaint. We'd waive any reading at this time. He would stand mute to the sole count. The address on that criminal complaint is accurate, and he is eligible for public defender representation.
All right, thank you. Mr. Elisius is in custody on, I think, a combination of cash bails and his other pending cases that are assigned to Judge McNamara. There may be a warrant from another county too. Yeah, it looks like Columbia County. Looks like they may have found some other event to have a new charge with here. We have to get this case assigned to Judge McNamara as well. State of a position regarding bail on this?
Looking for $1,000 cash, no contact with Home Depot. The defendant now has 6 open cases, 5 here, 1 in Columbia, 5 are felonies. Clearly cash bail, I think, is needed to incentivize his abiding by court orders. He does have that out of county bench warrant that you noted as well.
I'd ask for cash to be set at $250. It's a misdemeanor retail theft that was apparently discovered after he was already arrested. Bail's been set, I think, in this county totaling about $2,000 in cash. I think the highest cash It's maybe 1,000. I think the other ones are set at 500. He's indigent. He can't afford to post the bail that's already set. He was already in custody. There's no need for any further cash anyway, but if you're going to set cash bail, which I think might be appropriate at this time, $250 is an appropriate amount.
I'll set it at $500 cash. I'll adopt the condition that he not be at any Home Depot. I'm concerned about this event alleged to have occurred while he would have been on bond on a series of other events. I think it is a fair point to be made that he hasn't shown an ability to post what's already been set. I recognize that. I don't discount that. It's also the case that this bail would be at or around the same amount set in some of the other felony cases. If he can't post what's already been set, there's going to have to be either some global resolution of these cases or a more global look at bail. I think the number that's been set is really the least that's appropriate at this point. We'll get a not guilty plea entered for him and get the case sent on to Judge McNamara for further proceedings. Good luck to you, sir. Take care.
Do you have any PSIs today?
I haven't seen one yet, but
Okay. Saw one was filed in a case, but I don't think any of her.
Get you filed. That doesn't help.
yeah, they usually are e-filed, though, as you are aware, normally a printed copy is provided as well.
Yeah.
Mr. Rogers looks like he may be able to shed some light on that. Mr. Rogers, you're on mute.
I was trying to get it to turn off, but I was in the wrong spot. Yeah, so far there was only the one case that was uploaded on JARAUD LOTT.
Okay.
Nobody else fit the criteria for it being uploaded.
Oh my, okay. I will print a copy of that so that defense counsel has that.
Thanks.
Appreciate the information.
Great, thank you.
You see extradition that we were talking about earlier. I don't know what was resolved or if you need to. I assume Attorney Ferguson still needs to talk to him for the.
Yes, please.
I guess we'll get a brief. We do have one forfeiture. I don't know if Mr. Russell is down here, not down here yet. Fine.
Okay, so we'll be on a short break while Mr. Frederickson confers with the next client.
Mr. Olson, just so you're aware, we did forward a copy of Lott's PSA to you on your email.
Yes, I have it. Thank you.
All right, great. Thank you.
Subtle. All right, let's take up the case of Dane County versus Antonio Suttle, case 25 FO 2355. Appearances, please.
County by ADA David Olson.
And are you Mr. Suttle?
Hello,
Hi, is
how
that
you
you?
doing? Yeah, yes, sir.
Okay, some good news for you. It looks like the DA decided not to charge any of the criminal offenses that were part of the arrest. They
Okay,
have charged you instead, though, with a county ordinance violation. So it's more like a ticket, in this case for resisting or obstructing an officer.
okay,
You have some rights. One right is to enter a not guilty plea to that ticket. If you enter a not guilty plea, we're going to release you from jail. You won't have to post a bail. You would just get another court date later on.
okay,
And that, yeah, that would keep all your options open.
okay, thank you.
Is that what you want to do?
Yes, sir.
Okay, I'll accept the not guilty plea. We'll get it scheduled for further proceedings. I should probably see if there's a decent mailing address for you.
615 East Washington Avenue.
And I think the zip is 53703.
Yeah,
We'll get that processed here in the next room and get you on your way.
okay, thank you.
Good luck to you. Thanks.
Your Honor, if
Thank-
Mr. Suttle be interested in resolving today, the offer would be a no contest plea for court costs only.
So that would wind up being a fine of basically $114.50. So instead of the not guilty plea.
Okay, I'm gonna do the not guilty plea.
Okay,
Okay,
and either one is fine with me. I just want to
Okay.
make sure that we're on the same page.
okay, thank you.
Your preference is the not guilty plea?
Oh, I'm sure thank you.
Yep. Let me just make sure though that that's what
Okay.
you're saying, right?
Yes, yes,
So, yep. So you want to be able to have the next court date be released today and not.
yes,
Yeah, and not give up any rights today.
yes.
Gotcha. Okay. Thank you. We'll treat
Okay.
that as the not guilty plea like we started and we'll get you settled here in the next room.
Okay, thank you.
Take care. Bye-bye.
You too.
Appreciate it. Let's call the case of the state of Wisconsin versus Jorge Leon-SALGADO, case 25 CF 2702. Appearances, please.
State by ADA David Olson.
Jorge Leon-SALGADO appears in person, in custody, and by attorney Paul Frederickson. Good afternoon, Commissioner.
Good afternoon. I think you received a copy of the complaint alleging that he's wanted in Cook County, Illinois, on a charge of manufacture or delivery of 900 plus grams of cocaine. I believe counsel will also have the opportunity to speak privately with Mr. Leon about whether he wishes to contest extradition or waive his extradition right.
Commissioner, he wishes to contest it and have bail be set today.
And I should also swear the interpreter, Mr. Svensson, do you swear or affirm that you will truthfully and accurately interpret the proceedings?
Yes, I did.
Okay.
Te acabo de prestar por el documento también y por el-
Is the address on the complaint the best one to use?
Es la dirección que se debe usar para usted 6906 Road Road, número 229, o es esta? No, it's this one.
2417
241.
Alder Circle,
Alder Circle.
Middleton, Wisconsin. 53562 Alder Circles ALDER.
Thank you. And I can't recall what you said about public defender eligibility.
He is eligible for a public defender, Commissioner.
Does the state have a position regarding bail?
Well, Your Honor, the state is in possession of a governor's warrant. The state of Illinois is asking for no bond. If Your Honor is looking to set some amount of cash, I would ask for $50,000 to ensure his appearance and that the extradition could be effectuated.
And I think you did say that the state actually has a signed governor's warrant.
We do have a governor's warrant, yes.
Mr. Frederickson?
Commissioner, I'd ask for a modest cash bill to be set, perhaps $1,000 total. Mr. Leon-SALGADO has been here in Dane County for 13 years. He has 3 children, ages 24, 19, and 15, that all reside in Middleton, Wisconsin. He has been working in the community at Ars Remodeling, and he lost that job due to his arrest. My understanding is also this has been initiated in some way previously, and the state of Illinois failed to obtain a governor's warrant or send one over timely, which might explain why the state may or may not have a governor's warrant at this time. His bail amount would likely be moot at some point relatively soon if they'd actually produce and file that warrant, but we haven't seen that at this time.
And I do see that there's case 25 CF 930 where there was an allegation that he was wanted in the same county for the same charge with the same offense date. In that case, at the initial appearance, cash bail was set back in April. At $20,000, subsequently reduced to $5,000 in May. And it appears that it was posted the same day that that reduction occurred. If I'm following the court record correctly, it's consistent with what defense counsel said, that the case was dismissed with bond returned. I'd probably be remiss if I didn't point out that the booking sheet says that he's been in custody serving, I think, a totally unrelated sentence since sometime in September. Mr. Frederickson, maybe you have more to add in response to that, and when you're through, I'll certainly give the state an opportunity.
I don't have any information regarding the sentence that he's serving, Commissioner, but a number of $5,000 seems to be appropriate, given that that's what was set last time. I mean, he returned to court, he appeared voluntarily, they dismissed the case at that time. That demonstrates a willingness to appear in court. It demonstrates that that number was appropriate.
I don't know that I've ever had or recently had a case that's in this procedural status. Isn't there a process where the state can simply go to a judge and get an order of remand once a governor's warrant's been issued? I guess I don't know if that's 100% accurate or whether that is only accurate as it relates to a warrant that's produced post initial appearance. But I'm interested in thoughts about that from either party.
So, Your Honor, I'm firing from the hip somewhat here, but it's my recollection that the governor's warrant, once obtained, functions somewhat like an arrest warrant. So obviously proceedings had started against the defendant here. We have that warrant. I guess the next step procedurally with this case would be to get it in front of the judge, see if he wants to have a habeas hearing on it. But right now, I think as it relates to the bond request, at $5,000, that was set before the state had the governor's warrant. We have the governor's warrant now. It's almost an inevitability that he's going back to Cook County at this point, should the state prevail at any sort of next hearing, if there is one. So I think that makes the incentive for him to abscond even higher. It looks as if he has been, back in September, he pled to an OWI 3rd, which might be that current sentence that you're seeing. That was 5 months, so it's set to expire fairly soon here.
And anything else from?
I mean, I guess my point of view would be, no, it doesn't change any of his incentives at all, because he shows up to the 90-day hearing after having posted the $5,000 And most defense attorneys would tell their client at the 90-day hearing, you should expect to go in on that warrant. So he's out of custody, he shows up. In terms of whether or not they have a governor's warrant, I suppose I take the state at their word, but file it. Where is it? I mean, if it's here, then maybe, like I said, his bond is moot, but it hasn't been filed at this point. So he's entitled to have bail being set. $5,000 was enough to ensure him to return to court when he knew there was a possibility he would be arrested. He did that. That seems to be an appropriate amount.
All right, I'm gonna set cash bail at $20,000.
Yeah, it's that bait.
I'm not sure it's a given that a bail has to be set. I think the statute actually allows the court discretion not to set a bail in an extradition case. And also commands that the court not issue a bail if the offense is one that carries the possibility of life imprisonment or the death sentence. Happily, that's not our situation here. This is one where it is within the discretion of the court to set a bail, and I'm gonna do that. The offense alleges something north of a kilo of cocaine with a crime alleged to have occurred 7 or 8 years ago in another state where there's some demonstrated ability to post fairly substantial cash bails. And I guess I think that this case is today in a different procedural status than where things were when the $5,000 was previously set, posted, and he made the subsequent appearance. The point is well taken that the state could have, I suppose, produced the governor's warrant at that hearing, and he could have been taken into custody at that time, and that didn't happen. But the state appears to be much further through the process of providing for Mr. Leon's extradition at this point.
Isn't it also true, Commissioner, that he's had to sit significant amounts of times connected with this, and Illinois didn't care to have the governor's warrant done last time? I mean, in some ways, this makes it an even better case to lower the bail because we've been at this before and we don't have a warrant as we sit here today, or at least I haven't seen it. It hasn't been produced.
Well, part of my analysis here is if I understand the procedure correctly, the state or an agent of the state could serve the governor's warrant at some point and have further action taken separate from any bail that gets set.
Your Honor, I'm familiar with the protocol as far as we were to serve the warrant. I'm sorry, we were delivered the order, the warrant to serve today. So this was
given where we are procedurally right now, I'm gonna treat this as a conventional extradition initial appearance. I'm gonna set the $20,000 cash bail. We'll schedule it for a timely extradition hearing. I'll leave to the sheriff's office and the state what steps occur from here. I think that's beyond my control at this point. And we'll let it go at that. Take care.
That was my only one. Okay. Looks like we have somebody over Zoom. Do you know who that is? SINGH. All right, it looks like Mr. SINGH is over Zoom now.
I suppose we could proceed. Let's call the case of the state of Wisconsin versus AMAR SINGH. It's case number 25 CF 2700. Appearances, please.
State by ADA David Olson.
AMAR SINGH appears in person, in custody via Zoom, and by attorney Paul Frederickson present in the courtroom.
All right, I do want to confirm that Mr. SINGH can hear us okay. Maybe we can get him unmuted. We can talk about that. Yeah, Mr. Singh, you can hear us all right?
Yes, sir.
And were they able to give you a copy of the criminal complaint?
Yeah.
Okay, and I do see you're holding it there. Very good. We're gonna get this case assigned to Judge White because he's assigned to Mr. Singh's various other open cases. Where are we at with getting Mr. Singh a lawyer?
Commissioner, I am not aware about whether or not he's eligible for a public defender.
Okay, so Mr. Singh, you do have the right to a lawyer. You could apply through the public defender's office. I think you have a lawyer in your other cases, so whatever process you use to apply there should also work here. You could also hire a lawyer on your own or represent yourself. Those are all options potentially available.
Sure.
And Mr. Olson, any position regarding bail?
He asking for $500 cash due to the nature of the offense and to hopefully stop a sentence credit headache down the line. No contact with Bruce N, that's BRUCE, last initial N as in Nancy.
And Mr. Frederickson?
I'll ask for $250 cash, Commissioner. That's consistent with his other two cases that have cash bail. I would also note, as this court is aware, it is charged as an attempted battery by prisoner. I don't have any further information.
All right, let me take a little bit closer look at the complaint.
I'm sorry, sir, I'm homeless. Please, if you do something for me, I'm sorry, I don't do again. I apologize.
Hey, Mr. Singh, everything you're saying is to be taken down by a court reporter, so you really should refrain from talking about the facts in the case. You are currently on a cash bail on 2 other cases, so you would not be released no matter what happens with this hearing today, but I would advise you to be really careful about what you say in open court, okay?
Yeah, sir, because I know, can you don't find me for this case? I don't have any cash. Please, can you remove my? Can you give me a signature bond for this case? I really begging for these things. Can you give me a signature bond this case? And I don't do nothing wrong for in the future. I really apologize, sir.
All right, I appreciate sharing that situation, and I understand that, as noted by Mr. Frederickson, you're already in custody on other cash bails that you have not posted. However, I now have a complaint that is charged as attempted battery by prisoner, and that's a fair point that's made. Frankly, there's probable cause for a completed battery, but it's not a situation where I'm willing to set a signature bond. I'll set cash bail at $500. I'll order that he not have contact with Bruce N. Obviously, that is a restriction on him having intentional contact with that person. I would suspect that the jail is keeping them separate at this point, but if not, that's not on Mr. Singh, as long as Mr. Singh himself doesn't initiate contact.
We'd ask for prelim be set, Commissioner.
Fair, we'll get it scheduled for a prelim within the next 20 days. Good luck to you, Mr. Singh. Take care.
Next up is Gregory Morris.
Let's call the case of the state versus Gregory Morris, case 25 CF 2697. Appearances, please.
State by ADA David Olson.
Gregory Morris appears in person in custody and by attorney Paul Frederickson. Commissioner, we have a copy of the criminal complaint. We'd waive it reading at this time. He would stand mute. He is eligible for public defender representation, and the best mailing address is 521 East Black Avenue, apartment 6, Springfield, Illinois, 62702.
Thank you. We'll get that address updated. State of a position regarding bail.
Asking for $10,000 cash, no contact with the victims of this offense, Old National Bank, that he not use or possess any financial or identifying information that is not in his name or belonging to another person or entity. It's my understanding the defendant is from Illinois, as confirmed by his mailing address, and for some reason or another was either brought or came to Wisconsin to commit these offenses. It appears as if he has been charged in Illinois for similar conduct and is facing lengthy incarceration, which I think gives him an incentive to not appear in Wisconsin for court.
Mr. Fredericks.
Yeah, Commissioner, I haven't heard anything about any missed court appearances. These are non-violent property crimes that are being alleged here. There's no reason to believe that Mr. Morris would not appear on these charges. Actually, maybe especially so if he has charges in Illinois and has made all of his appearances at this time. Mr. Morris has a daughter with special needs that he is responsible for taking care of. He also has a significant other that is pregnant and he's expecting another child on the way. He has been able to work in the past. I haven't heard any reason to suggest that he will not appear in court other than the fact that he lives out of state, which is not a reason in and of itself to set cash bail, especially at $10,000. So I would ask for a signature bond. He is indigent. He qualifies for public defender representation as well.
The complaint alleges that he was in possession of and alleges that he actually used multiple forms of false identification with different names, that has no ties to the immediate area. All the reasonable inferences are that he came to the area to commit the crimes that are alleged in the complaint. And there's information suggesting similar behaviors in at least 2 other states. The amount of bail requested by the state is, doing some quick math, about 40% or so of the amount that he is said to have confessed to having taken here in the Madison area. It's the very least I'd be willing to set. I'll set $10,000 cash bail. I'll order that he not be physically present at any financial institution. We'll get it scheduled for a prelim within the next 10 days.
I don't have.
Okay, sorry, sir. Okay, so the response of ZEPEDA-SAMANO.
What's called the case of the state versus Juan ZEPEDA-SAMANO, case 25 CF 2698. Appearances, please.
State by ADA David Olson.
Juan ZEPEDA-SAMANO appears in person in custody and by attorney Paul Frederickson. Commissioner, we have a copy of the criminal complaint. We waive its reading at this time. He would stand mute. The address on that complaint is the best mailing address, and he is not eligible for public defender rep.
All right, very good. So it sounds like they're saying you either make too much money or have too many assets to have a public defender. The deputy is still going to hand you a sheet that describes how to apply there. Sometimes people's incomes change and it's worth reapplying, or sometimes they just want to have the numbers checked again. That's okay. You also could hire a lawyer on your own. You could represent yourself. If the public defender's office still says no and you don't really think you have the money to hire a lawyer, there's a process where you can apply through the clerk of court's office. Sometimes they can get you a lawyer with a payment plan. You're in good hands for today, though. What's the state's position regarding bail?
Signature bond, no contact with Jonathan T. and a ban from Soto nightclub in Madison. No possession or consumption of alcohol.
No objection.
Well, that's what the state's asking to have imposed. I'm just going to look at the complaint a little closer to see if I'm willing to go along with that. And I am willing to go along with it. It's a close call, given the substantial battery charge and the resisting allegation. The resisting allegation appears on the relatively minor end of the scale. Let's give it a try. We'll do a signature bond. I'll adopt the non-monetary conditions proposed by the state. Should we put on a prelim within the next 20 days?
Commissioner, I'd ask the prelim be set.
Give us a fine. We'll get a prelim scheduled within 20 days. That just means you're gonna have to work right away to get yourself hooked up with a lawyer so that you have somebody to represent you and you aren't stuck representing yourself at that hearing. So please get on that as soon as you're released. Good luck to you. Take care.
Next up is John Sullivan.
All right, we'll call the case of the state versus John Sullivan Senior, case 25 CM 2852. Appearances, please.
State by ADA David Olson.
John Sullivan appears in person, in custody, and by attorney Paul Frederickson. We have a copy of the criminal complaint. We'd waive its reading at this time. He would stand mute to the sole charge. That address on the criminal complaint is accurate, and he is eligible for public defender representation.
All right, thank you. And does the state have a position on bail?
Be asking for a signature bond, a condition that he have no contact with Zebediah Y, ZEBIDAH, last initial Y, and that he not possess any controlled substances or paraphernalia without a valid prescription.
She lives in my house. She's not paying her. She's there for a few days. The police say I can't remove her. What do you call that? So. I'm not gonna be able to return what if they do no contact. That was for 3 days. It's my own house. She's a crasher. She doesn't belong in my home.
All right.
I have 3 people that are supposed to be able bona fide renters there. She came as a guest on home. She won't leave.
Okay.
That's what the whole thing stemmed from.
All right, Commissioner, I would ask that the condition be no acts or threats of violence regarding the alleged victim in this case. Apparently they do live at the same residence, although what exactly the arrangement of that is a little bit unclear at this time. I don't think that there's any prior history between the two. I don't think that this criminal complaint is suggesting a lengthy history. I think the no acts or threats towards the victim is appropriate in this case.
She's a squatter, what it is.
I understand.
And this isn't determinative, but it's informational, and I think it might be helpful for everyone to know. The clerk has identified that the 72-hour no contact prohibition was enforced and will be in effect until tomorrow morning at 8:15. So that'll be in place, I suppose, regardless of what we do for bail, but this is still an important independent decision. Any response from the state regarding that?
Your Honor, I would just ask for the no contact. It's obvious. Victim desires it with the 72 hours. There are allegations that the defendant made some more or less violent statements towards the victim in this matter. So I think that the no contact is important to protect the victim.
Well, let me take a closer look at the complaint. All right.
I'm just reading this, Your Honor.
Oh, okay. I just wanted to make sure you weren't having some kind of a medical issue or something. All right, I did take a quick look at the complaint again. I don't know that anything new's been added, but if either counsel has anything to add, that's fine.
And the only thing I would say, from a quick review of Mr. Sullivan's criminal history, it looks like his last conviction was in 2003 and it was an OWY. That's a pretty long history of no domestics, no violence. It apparently is his home that he owns. If you were to adopt a strict no contact, you would be making him homeless in his own home that apparently he owns. So I would ask that you order no acts or threats of violence, with the understanding that he could not return home until the 72 hours is up in any event. And I think that is a very important thing for him to understand at this point.
And anything else from the state?
No, Your Honor, thank you.
house has been taken over by the gangster disciples. This woman's an associate with them.
Okay, so, I guess it isn't really all that clear to me what the nature of either the relationship or the tenancy is at this home. I know that defense counsel, I think, referred to that as fuzzy or used a similar sort of term.
You can see
earlier.
within the complaint, it says something, there's an indication that he would evict her if she reported something, which indicates to me that there's not really a true domestic relationship, that there is some sort of tenancy relationship, and this is distinct from a power of control, though living together does meet the statutory criteria, so I'm not challenging that, obviously, Commissioner.
Yeah, and it's the same struggle I have in trying to look through this and figure out what an appropriate response is. It isn't really my specific intention to prevent Mr. Sullivan from being able to be at his own home. I think that's reasonable under the circumstances. It's also reasonable to have there be an order that keeps the two of them apart right now, given what's alleged in this complaint and what would seem to be, by kind of either side's account, a toxic relationship, whatever that is. I don't think I can really in good conscience not order the no contact at this point. I think it's appropriate to order that. I'll order a signature bond with the no contact condition. I'm not going to set a specific like geographic ban involving the home or the residence or anything like that. I'm also going to decline to order the controlled substance or drug paraphernalia condition simply because that's against the law anyway.
Maybe heard on the no contact briefly. Can we
Yeah,
allow contact either by phone or writing? For instance, if she is actually a tenant and he wants to go through eviction proceedings, I think he shouldn't be barred from doing that based on this case, right? Like,
Well, I agree completely with that. If there's a valid basis for a lawful eviction process, the no contact order shouldn't prevent his ability to pursue those rights. And maybe what I'll do is indicate that there's an exception to the no contact order for any incidental contact occurring in the course of court proceedings or with regard to the filing and service of any lawsuit.
Okay.
I think that allows him to proceed if that's his desire and it's otherwise appropriate, while also providing the protection that I think the state reasonably requests in this situation. It's not a perfect answer. I think it's kind of the best one we have for today, unfortunately. We'll get a not guilty plea entered on Mr. Sullivan's behalf. Safest course might be to use a lawyer to help with that process so that there isn't some misunderstanding or something that's construed as an unlawful form of contact or something that would be intimidating in nature. Mr. Sullivan, good luck to you. I hope things improve.
May I speak?
You can, but here's the downside. The court reporter takes down everything that's said. And a good amount of the time when somebody wants to talk at this court date, they say something that gets used against them later on. And I don't want to see that happen. You had a lawyer here who spoke well on your behalf, and I think leaving it at that might be the wiser course. It's up to you. I'm not going to tell you not to.
Okay, Your Honor, I've been in that house 25 years. There's been no trouble. My house has been taken over by gangers. They call it gangster disciples. They were in there selling cocaine, selling women. My house is totally, I'm a prisoner in my own home. They've stolen my debit card, they've smashed my hearing aids. There's been constant police, complaining to the police, please help me get these people out of here. Help me get them off. They have, this ZEPEDA, they squatters, how she got there. She came with the guest of 3 people that I've allowed to be in my home to supposedly rent from me. They're not paying me any rent, so. And she was there, would not leave night after night after night. After so many nights, they have squatters' rights, the police tell me. They have a right to be there. I have to go through the eviction process, which is $98 per person for $45 to have it delivered. I'm a disabled veteran, collecting my veteran's disability pay and my social security. I'm 32 years old. I'm constantly bullied in that house. They have totally destroyed my home. That morning I woke up, I came in, there were 2 more people. You have to know this is what.
Well, here's the problem, Mr. Sullivan. I don't have the legal authority to evict the other people or enter any orders with regard to them in the context of this criminal case. You've correctly identified one of the rights you do have, which, well, two of the rights. One is to contact the police about crimes that you believe have occurred. The other is to pursue a lawful eviction action. Depending on your financial situation, sometimes the fees for those things can be waived. That is a possibility sometimes.
The police said either I get a emergency restraining order against this woman and these people in my house, or or I go through this route of eviction, which I was waiting. I just got my check today, my VA disability. I was going to do that. And they told me this has been like a planned type thing. They said, you're gonna end up in homeless shelter, Sullivan, and we're gonna be in your house. This is a street game I'm dealing
Well,
with. There's been gunfire in front of my house. There has been a gun laid in front of me on the table with an extended magazine, a handgun. There has been a guy and two men, one had a gun and a knife in my living room. I am terrified. I am terrified to be in my own home. I'm by myself. I have no one. I gotta depend on this rent, which you're not paying me, like I say.
And I do hear what you're saying, Mr. Sullivan. You identified actually a third option there too, which was applying for a restraining order. That gets done on the ground floor of the courthouse. In many cases, there's not actually a fee for that either.
I don't know their names, Your Honor. I don't even know these people's names. That's how bad it is. I know their street name. The ZEPEDA, she said she's a street boss, okay? I don't know their names. How can I?
I totally hear the concern that you're making. Or that you're stating, what you're describing here. I don't have a lot of great solutions for it other than the other lawful
May I apply
solutions.
for that?
That have already been discussed.
But may I apply for that restraining order today? Can I go wherever I gotta go and get this done? I mean, I'm not gonna be put out of my home.
Yeah, so, right, so, and I'm not trying to be a wiseacre with you. Literally, the sooner we finish this hearing is the sooner that you'll be able to be released from jail, which will increase the odds that you could get to the courthouse before it closes to apply for anything that you wanted to apply for. I'm not promising whether there's grounds or I'm not taking a position on who's right on any of this. I hear what you're saying. And if you have rights, you should pursue those, and I totally respect that. But I can't do anything about what you're describing in the context of this case right here today.
So could I go home now? Am I gonna be able to go to?
As long as that person isn't there, but you can't have contact with her.
So I'm blacked out of my home, Your Honor.
Maybe for right this moment, that might be true.
I'm so angry.
I understand. So we're gonna get you some paperwork here. I hope things improve for you, Mr. Sullivan.
Next up is ANDREAS. More.
All right, why don't we call the case of the state versus Andreas Moore. It's case 25 CM 2851. Appearances, please.
State by ADA David Olson.
Andreas Moore appears in person, in custody, and by attorney Paul Frederickson. Commissioner, we have a copy of the complaint. We'd waive its reading. He would stand mute. He's eligible for a public defender, and the best mailing address is the one on the criminal complaint.
All right, thank you. The complaint alleges that he does have a couple of open misdemeanor cases. Okay, well, I'll take a break while we get him a chair. That's fine. There we go. All right, so yeah, he does have a couple of open misdemeanor cases assigned to Judge McNamara. We have to get this case assigned to the same judge. Maybe the state has a position regarding bail.
Well, as it relates to bail, I'd be asking for $750 cash, condition of no possession of controlled substances or drug paraphernalia without a valid prescription, knowing how your honor feels about that condition. As it relates to these open cases, Mr. Moore failed to appear in 24 CM 2845 on February 26, 25. That warrant was then served March 19th, same year. He was given a signature bond the next day and then again fails to appear March the 28th of 25. He was again given a signature bond September 2nd of 25, fails to appear October 29th. He has received a $200 cash bond in 25 CM 2816, which happened on the 25th, which is 3 days before this incident. So I think given those failures to appear, a cash bond is necessary to ensure his future appearance.
You're right.
Commissioner, if you are going to impose cash, I'd ask you to ask cash bail about $300. That is an increase from the $200 that was already posted. Mr. Moore is indigent. He receives SSDI. The court has observed his various mobility issues and difficulties getting to court and being even in the courtroom at this time. He's living in Dane County all of his life. I don't believe I could be wrong about this, but he doesn't have an attorney on his underlying case, which might have contributed to his non-appearances. I think that's an unfortunate situation. The allegations here, as well as a relatively minor possession of drug paraphernalia. I understand there's bail jumpings attached to that, but this is a relatively minor offense. I think $300 is appropriate under the circumstances.
And Attorney Sheehan was appointed today, so
That makes
recent development.
Yeah, fair.
Any response from the state?
No, Your Honor, thank you.
Okay, I think the defense position is reasonable. I'll adopt it. I'll set cash bail at $300. I'm not gonna set the controlled substance or drug paraphernalia condition. Again, I know it was set in the earlier two cases by other commissioners and I respect that. I appreciate it. I just don't know that there's much value added by adding it here. And I'll even note the state didn't even charge him with violating that condition. Despite the fact that the complaint suggests that he could have been. We'll get a not guilty plea entered on Mr. Moore's behalf. I hope things go better for you this time, Mr. Moore. Take care.
Thank you.
You're welcome.
And I'm sorry, did we enter not guilty plea on his behalf?
Yeah, we will.
Okay.
Yeah.
Next up is Timothy Webster.
All right, I will call the case of the state versus Timothy Webster. It's case 25 CF 2701. Appearances, please.
State by ADA David Olson.
Timothy Webster appears in person in custody and by attorney Paul Frederickson. Commissioner, we have a copy of the criminal complaint. We'd waive its reading. He would stand mute. The address on that complaint is accurate and he is eligible for a public defender representation.
All right, thank you. The booking sheet says that he is being held on a probation hold. Looks like that was from a conviction in branch 11. So this case would have to get assigned to Judge Burrs as well. Does the state have a position regarding bail?
Your Honor, he is on a hold, so this makes it rather moot. I'd be asking for $1,500 cash, condition that he not possess or use controlled substances or paraphernalia without valid prescription. Again, understanding your prior rulings. Mr. Webster is on probation for what's classified here in the notes as an aggravated flee and elude, where he admitted to running from police because he's afraid to go to jail. And here, within a year, he does very similar conduct. Law enforcement initiates a traffic stop for a registration violation. He does stop his car, but then ditches it on foot. And when arrested, he says again, I'm scared, and then was wondering if he's gonna go to prison. And again, similar to that last case, has controlled substances on his person. So I think given the repeated nature of the conduct here and that hold, a cash bond is appropriate.
Commissioner, I'd ask you to set cash bail in the amount of $500. Mr. Webster is indigent. He has lifelong ties to this community. He has 3 children and then another one on the way that he's expecting, ages 16, 14, and 6. He has previously worked and instead now has been working on schooling for culinary arts and engaging in treatment while on supervision. In order for him to even be released, he would almost certainly have enhanced scrutiny, enhanced rules, and an alternative to revocation given these charges. So I think $500 is an appropriate amount. It means he has to post some cash in order to be released, but it is consistent with his indigency and other factors.
Any response from the state?
No, Your Honor.
Honestly, both recommendations are reasonable for the stated reasons. I'm willing to go along with the defense recommendation in this case. I'm of a mind that the cash bail is necessary because of the resisting type nature of the allegations. I'm happy that there's not really significant evidence of effort to flee in a vehicle, which changes things a lot. So we'll make it the $500 cash bail. I'm going to decline to set the drug-related condition of bail because it duplicates the law that applies whether it's set or not. Do you want a prelim within the next 20 days?
We do.
Okay, we'll get that scheduled. Good luck, Mr. Webster.
Jared Lott.
Yeah, but I'm gonna post file.
I wasn't.
All right, we will call the case of the state versus Jared Lott, case 25 CF 2699. Appearances, please.
State by ADA David Olson.
Jared Lott appears in person in custody by attorney Paul Frederickson. Commissioner, we have a copy of the criminal complaint. We'd waive its reading. He would stand mute to the sole count. The address on that complaint is the best mailing address, and he is eligible for public defender representation.
All right, thank you. Does the state have a position on bail?
Your Honor, I'd be requesting cash bond in the amount of $2,000, then he not operate a motor vehicle without a valid driver's license. Part of this request is due to the conduct that's on display throughout the criminal complaint, the underlying charges of fleeing here. And then per DOC, it's my understanding that the defendant is on supervision from Illinois from a Kentucky case. So I think there are out-of-state ties here as well that lead to a cash bond.
Mr. Frederickson?
Commissioner, I'd ask for a signature bond. We do have an evidence-based tool that does recommend a signature bond. We do not have any prior missed court appearances, no prior violent convictions, no prior sentences to incarceration, at least according to this. Mr. Lott also has a child 10 years old, has been residing in Dane County for some period of time, has siblings and extended family in this area. And has been in the area helping out his extended family, from what I understand. He's indigent, he cannot afford to post cash. I would ask you to adopt a signature bond in this case, Commissioner.
All right, I'm persuaded based on the nature of the allegations as well as the dangerousness of the driving described in this complaint that cash bail is appropriate. It should be substantial cash bail. The state's requested number is quite reasonable under the circumstances. I'm also concerned about the statements Mr. Lott made to law enforcement that I think in some ways were cooperative, but they also suggest a likelihood of a repeat performance if he were to be stopped in the future. I'm going to set cash bail at $2,000. The condition of bond is going to be that he not operate a motor vehicle. I'm not conditioning that on whether he has a license or not. The dangerousness appears to be connected to driving as a whole here. We'll get a not guilty plea entered on his behalf to any misdemeanor charges, though I don't think there are any. Should we put out a prelim right away?
We should.
Okay, we'll do that.
2,000, sure, let's get out, but then you have like the whole. Too, okay. You can enter it into some of that. Sure.
All right, that's everybody's today.